Hey, welcome to the No State Project. I'm your host, Marc Stevens, author of Government Indicted, which you can get at markstevens.net. And you're here listening live, of course, to the 26th episode of the No State Project, where we do it live here, commercial-free on Ustream, which hopefully within a couple of weeks we're going to be doing directly on my YouTube channel, which, of course, is No State Project. We are live from the fortified compound in Mesa, Arizona, and if you would like to join me on the big show today, you may do so at 218-632-9399. The passcode is 2020 and the pound sign, 2020 and that there pound sign. You can also join me on Skype, but don't call me, instant message me first, and then we can bring you up on the big show. It is Frank Rizzo 3. That's Frank Rizzo with the number 3. And I want to thank everybody for their continued support. Again, with the non-entity, I really appreciate it. Got to see non-entity yesterday. Do appreciate the support. I'm going to be getting more acoustic panels and getting the sound even better here on the big show. Although the content is engaging enough that, but still, we'd like to get it the best that we can. Remember, we got Jackalope in just a couple of weeks, July 31st to August 6th in Bacchus Meadow. Go just do a search for, or go to markstevens.net, and you get information about that. It's about an hour and a half to 2 hours northeast of Phoenix, and it's going to be nice. It's going to be beautiful. It's gorgeous up there. And Calvin will be with me, and we're going to be bringing some guitars. So be able to do a jam. But speaking of a jam, I got this. That's what made it. It wasn't a complete waste of time yesterday. That non-entity was there, so we were able to catch up and visit. I'm not going to be promoting that Desert Eagle place anymore as far as open mic, because it's a little bit of a misnomer that it's an open mic. It's more or less this group of guys that just monopolize the time, and after almost 2 hours, I said I'm not going to get an opportunity to play. We do have another place that might work out as an open mic. That's the thing. I know guys get comfortable and want to play, and it's a lot of fun to play. That's why I was there. But, when you got one or two people that will not leave and just continue playing and playing and playing, even though there's a list of people who would like to play, kind of a douche move. Kind of a really, real douche move. But we'll find a place to do it. But what's reared its ugly head again on my forum, which all are welcome to criticize. But one of the things that you want to see with the criticism is you want it to be honest criticism. The continual lie that every single time that I have filed a motion with my arguments that that there's no evidence from the prosecution to meet their burden of proof, that every single time it's been rejected, this lying piece of prosecutorial garbage just keeps saying that the same lie. Every single time I've raised it, every single time it has been denied, which is not true. So if you're going to criticize the material, for goodness sakes, at least pull your head out of your butt long enough to actually make a valid argument. Make a valid criticism. Stop this strawmanning crap and just flat out lying. So we're going to get to the call in a moment. I'll talk more about this. In fact, I got to do a whole video about this because people really need to see point by point just how freaking dishonest these people are. So what I want to put out there, I don't want anyone to actually give any money right now. Support of the show is always welcome. Appreciate that. But what I want to do is make it even more obvious just how dishonest someone like Wesley Serra is. Now, he's a former prosecutor. He's come back on the website to gloat months after the fact, how he just froths at the mouth, just loves that the courts are being dishonest. And I'll show point by point just how dishonest they are and how dishonest Wesley Serra is. Now, I've done a few videos of him before. The man just can't stop lying. But anyway, what I'd like to be able to do is to show how dishonest this man is. How he's just he's a shill for the system, which has made him probably very, very wealthy. So why he feels the need to shill on my little website that doesn't get much traffic, I don't know. But I'd like to see him do a live broadcast. I know he's not going to because it's excuse after excuse after excuse. I control the live stream, which is ridiculous. I can cut him off at any moment. And I've got evidence to show that's not true. I have patience up to, look, I've had people, very harsh critics. I've had them on for hours. I have never just cut it. The only time I've cut it, if you get on the show and you start slinging homosexual slurs and stuff like that, yeah, I'm going to cut you. Not because I'm afraid of your argument and I can't defeat your argument, but because I don't want to hear homosexual slurs. I don't want to hear slurs, period. So what I want to do is have people pledge. Just make a public pledge at markstevens.net. You can go on the forum. Maybe I'll start a thread with that. But we'll start a pledge drive. So what we'll do is pledge money that could then send to one of Wesley Serra's favorite charities. That if he will do at least a 1/2 hour live broadcast with me, the money goes to the charity of his choice. Give it a shot. He comes to the website and says that states exist whether I think they do or not. So I ask him point blank, where is your proof? They don't exist just because you say so, and they don't not exist just because I say so. But if you're going to make a claim, remember, the burden of proof lies with the one making the accusation. The one who makes the claim bears the burden. Wesley Serra, you believe states and citizens are real. You believe that there are governments. Where is your proof? It's been at least a year since I first started asking you that on the forum, and you just you just ran away. Evidence, not court citations, not your opinion, not philosophy. Evidence, prove that reciprocal obligations of allegiance and protection were actually created. I'm confident that you can prove that, and you know you can't prove that because the evidence is against you. A wise man conforms his belief to the evidence. That's your signature on the forum. You don't actually believe that, though, because your reality is dictated by what some filthy attorney in a robe says, not the evidence. You couldn't care less about the evidence. The evidence means nothing to you, especially if you get a chance to piss and whine and complain or piss all over somebody and gloat that a peaceful man not accused of doing any harm to anybody, you can gloat that he has lost in court again. That was over 6 months ago, and it's not necessarily over yet. There hasn't been a ruling on the motion for a rehearing in bank. So you got even that wrong. But you're posting something from 6 or 8 months ago. Anyway. So let's see what we can do. We'll get a pledge drive. Maybe we can raise a few $100s for Wes's favorite charity. We'll see what we get. So maybe we can get this. We'll have to start. I can do it, or maybe somebody can start the pledge drive for this on the forum at markstevens.net. If you go to the forum, you can see this nonsense, this trash. And again, he's a former prosecutor, so he's very much in the government good, the state is never wrong kind of mindset. He's an ambulance chasing personal injury attorney now, and he's just gloating. To me, I think this is disgraceful to gloat over this. Because maybe if he actually met and spoke to James, who was the one that was the subject of this attack, if he actually met him and understood a little bit more, he wouldn't be such a douchebag and make such a douche move by gloating over this. What is over is the fact that regardless if James ever prevails in this, it doesn't matter because the IRS has already dropped it. Whatever they were looking to get from him, they've already done it, which was testimony. They've already done it. So there's no correcting this. There's no correcting it. But what the thing is, he actually links the brief, which I wrote, and I'm going to go through that. And this is something that you'll see in the decision that is also posted that the court never addresses. So the main issues here are a lack of evidence. And this is such garbage They actually, all right. The attorney who I've mentioned in previous videos, Montoya, attacks Jim, claiming that he is making only conclusory statements. Yet, the entire position of the IRS, which was Evan Moses, the entire thing was conclusory statements, saying that just because Jim is physically in California, and therefore the Constitution applies, is a conclusory statement. So when we asked about evidence, they didn't have any. So by their own standard, Wes, and all those trolls and shills who believe that this stuff is valid, if you're using the principle that Montoya laid out, that conclusory statements are not sufficient, why not apply that to your heroes, the IRS? Yeah, so why not apply that standard to the U.S. Attorney? It never was, because there's an unfair double standard here. All Judge Boone did was literally repeat the arguments from Evan Moses and Montoya. That's all he did. Repeating an argument doesn't make it true. And just repeating conclusory statements does not give it support. So we even put in here, because we agree. This is Ashcroft versus Iqbal, 556 U.S. 662. While legal conclusions can provide the complaint's framework, they must be supported by factual allegations. Now, anybody who's honest can see and understand and accept. When you say the Constitution applies because he's physically in California, that is a conclusory statement. There's no evidence to support that. And the Supreme Court, that's the Supreme Court decision. Legal conclusions, that's what it was. Where are they supported by factual allegations? Wes, you dishonest person, you. Why don't you apply that same standard to the U.S. Attorney? Why does the U.S. Attorney get to make conclusory statements, legal conclusions with no evidence to support? Now we also bring out that, and we have the dates for this. I spoke to Evan Moses. I spoke to the agent. And we have the date and time, and we have the recording on CD. We have this recorded. This is evidence. It was completely ignored. So when you go to the decision, where the decision doesn't address this, all it says is the district court did not clearly err by granting the petition because the United States met its burden of establishing its prima facie case for enforcement of the IRS summons, and Witt failed to rebut that showing. That is a lie. Having a CD with Evan Moses' own words that he had no evidence to support those legal conclusions. So it's not just that they're conclusory statements with no factual support. The actual witness, the IRS agent that Wes cannot stop filleting. He can't stop filleting Moses and Judge Boone long enough to realize Evan Moses admitted to not having any evidence. So here you've got not just that we're pointing out the obvious truth, that there is only a conclusory statement with no factual support. So what about Ashcroft versus Iqbal, right? What about your sacred law? No, we also have the actual witness telling me, and we have the date and time with the CD, 27 April 2005. So remember, and I'll put this up in another video, maybe I'll put it here again. Gary Murphy from the Wyoming office telling the office, the IRS office there in Wyoming, not to take phone calls from me, because I have over 24 calls to the IRS that are very embarrassing to the agency because they don't have the damn evidence. Because conclusory statements are not enough. They have to be supported by factual allegations, and Evan Moses didn't have that. So, Wes, you have to pull your mouth off of Judge Boone's ass long enough to apply some actual logic and reason and critical thinking. But you're not going to do that. And you won't come on the show even if we raised $1 million to have you come on. Because you have no evidence. you and your compadres there, all you want to do is piss on the work without showing where it's actually an error. Even at the very least, with Evan Moses, with the admission that he made, the very least, they should have given Jim, they shouldn't have canceled the order to show cause hearing. But the moment he filed the paperwork and with the CD, that he was going of Evan Moses' own words, that Boone scumbag, that piece of garbage Boone, federal judge, canceled the show cause hearing so that Jim did not have the opportunity to put Evan on the stand. Do you see any mention? There's no mention of the CD in here. There's no mention of the evidence. Zero. They don't say anything about Evan Moses and his own testimony, and that Boone did not address that. They don't even address here the fact that the order to show cause hearing, where he had the opportunity to put Evan on the stand, they don't say anything about that. They never address that. And it says, once a prima facie case is made, a heavy burden is placed on the taxpayer to show an abuse of process or the lack of institutional good faith. Excuse me, under your own sacred rules, you have to be able to confront your accuser. And having the witness, I'm going to just I guess I have to keep repeating myself. The witness himself said that his legal conclusions, he had no evidence. He admitted to being unqualified to make those legal determinations. All the legal determinations Wes is championing right now, the one who made them admitted that he wasn't qualified. At the very least, you've got to put him on the stand for a cross-examination. No, instead you just want to be like a child and start and gloat. Hey, Marc's wrong. Really? Really? We're going to have to maybe get it posted. Evan Moses testified, or he said that he was not qualified to make those determinations against Jim. Then you've got a scumbag like Boone and Montoya, who it was disgraceful. They don't even allow him to confront the witness. And you're going to say that this is legitimate? Marc Stevens' work is wrong because the judges disagreed? Oh, pull your head. Oh, please, give me a break. Give me a break. This is as dishonest as you can get. We reject as without merit which contentions that the district court was biased and violated his due process rights. Excuse me. The judge had no discretion to not allow a cross-examination of the agent. Because all we have to do, U.S. versus Harris, U.S. versus Roundtree, all we have to do, and I know it's a summary proceeding, I know, but you still get discovery and you still have to confront the witness if you have evidence that puts the credibility or competency of the witness at issue. The witness saying he wasn't qualified. That's the thing. The witness himself said he wasn't qualified to do what he did. And then he lied, saying that his attorney would discuss the matters with us. And of course, Miss Montoya refused to do that. Why? Because Miss Montoya is a crook, just like you, Wes. A dishonest crook. So none of this is something that goes into your analysis, which your analysis is really just to call me a schlub and a fraud and a wacko. Nothing in this, and I'll have this in the video, nothing in here addresses the actual specific claims that we made. It's just, in a broad sense, they're just denying it. Well, we don't see it. Why is there no mention of the recording? Why is there no mention of the denial of cross-examination? Why is there no mention of why the judge canceled the order to show cause hearing? Imagine it. The judge issues an order to show cause. You have to come in here and show cause, and you say, well, okay, but I'm going to cross-examine the witness against me, and they cancel it. Does Wes want to offer any reason why? All you can do here, everybody, all anyone can do is say, well, maybe the court was right. He didn't meet his burden. What Evan said really doesn't rise to the level. Really? Imagine the witness saying, even before any kind of trial, I'm not qualified to have said that. I have no evidence. You see, that's why I say things like that Wes is too busy filleting the judge to understand basic principles of logic or even the basic principles of a fair trial. If you could stop kissing the judge's, ass like that and apply the same principles that you say are so valid and sacred, you'd see that Jim was treated unfairly. It doesn't matter if a three-judge panel agreed with that. They didn't address the issue. I can clearly show. I've already done that several times. Not just today. This is complete horse crap. See, there's a lot more that goes on behind the scenes that don't come out in these. And so it's interesting when you read this disposition is not appropriate for publication and is not precedent, except as provided by Ninth Circuit Rule 36-3. Do you think they want to actually publish the arguments that Jim made? And no, this is why you don't get oral argument. Because you could actually say, could you please, can the other side, Ms. Montoya, can they actually give a valid argument as to why I couldn't confront the witness? Can they give an argument as to why the CD should not have been considered at all? It wasn't a matter of that it wasn't admissible evidence. Because we still had me as a witness. I was on the call. Jim was on the call. Even if you throw the tape out, you still have two witnesses to the matter. And there's no legal justification then to deny cross-examination. Absolutely disgraceful. And for someone to come on the forum and cheerlead for this kind of crap tells you what kind of person they are. We know what kind of person they are. They're dishonest. And these are all appealable issues, by the way. These are big-time appealable issues. Big-time appealable issues. So somebody had asked, who was it wanted me to talk about appealable issues? Gabe was asking me about that. Everything we raised in this appeal was a good, strong, appealable issue. So the Boone actually tried to say that Moses' statements don't establish he's unqualified. The man said he was not qualified. And so if you're going to doubt the veracity or the validity of the witness's own statements, you have to put him on the stand and have him testify under oath. Now, the facts that we had to establish Boone's bias was that he accepted a legal conclusion from a witness, admittedly not qualified, as absolutely irrefutable. He went against the basic principle with the courts that a pleading, like I mentioned in Iqbal, while legal conclusions can provide the complaint's framework, they must be supported by factual allegations. Now, what they must have really meant was, while legal conclusions can provide the complaint's framework, they must be supported by factual allegations unless the complaint is filed by a scumbag U.S. attorney. Then they can make whatever legal conclusion they want. But he's a citizen! That is a legal conclusion that must be supported by factual allegations, which means if you're going to prove someone's a citizen, you have to prove that they're a member of the body politic owing a duty of allegiance in return for a duty of protection. These are reciprocal obligations, one a consideration for the other. So they must be supported by factual allegations. So you can shove your allegation of citizenship right up your ass because it's absolutely meritless and frivolous, yeah, I said it, without factual support. And if you turn around and say, they don't need evidence, that's again an unfair double standard. That's only championed by the worst of the worst. Prosecutors, cops, judges, and the scumbags who support them. That is the legal principle, and it's not being upheld. So that is evidence of bias. Why is he not applying the rules to the U.S. attorney, which he used to be, but he's not applying it to, but he is applying it to Jim, which is fine. But Jim didn't make any legal conclusions without factual support. So he actually said, Mr. Moses' actions do not establish that he lacks personal knowledge of the facts attested to in his declaration. That's what he said on the phone. So why would Judge Boone lie? Why would he lie if he wasn't so biased in favor of the IRS? How about fungal? You know they're lying. Boone is a liar. Just because he wears a robe doesn't mean he's not. He's just another scumbag lawyer. It was something that could have been brought out in a 5-minute cross-examination. But what they want to do is they don't want to show that Evan Moses perjured himself because he made the statement under oath. It was a felony. They allowed this man to make legal conclusions in an affidavit and then admits that he wasn't qualified or had the evidence. It's perjury. And yes, when you say that you issued the summons for a legitimate purpose under the law, that is a legal opinion, a legal determination. Denying confrontation of the only witness against you, holding Evan Moses up on a pedestal, having that, what he said is like Odin dictated himself, and not allowing cross-examination? No. Filth. You're garbage. You don't even allow a man to have a cross-examination on an order to show cause hearing you set. Did Boone give any grounds for canceling that order to show cause? Nope. Due process and fairness require that the evidence be tested in court. Even in a summary proceeding like this, you put the witness on the stand. This is no different, process-wise, than a police officer writing you a ticket, making legal allegations against you, and the scumbag in traffic court, the judge, finds you guilty after canceling the hearing. No confrontation, no discovery, no challenge allowed whatsoever. Now, if a judge did that in traffic court with all these IRS shills, all these government shills like Wes Serra, would you be championing that as fair? Oh, maybe you would, because a wise man conforms his beliefs to the evidence, not attorneys. See, it said wise man in there. It doesn't mean that Wes is a wise man. It doesn't mean that anyone at Quatloose is a wise man, because they form their beliefs from the opinions of these other lawyers, not from the evidence. So there's no difference. Who in the hell would justify as valid and legitimate and fair a parking ticket or a speeding ticket where you were found guilty without a trial and without being able to put the cop on the stand? And yet, the IRS gets away with it every single time. Every single time. Oh, well, not every single time, because we know they love to bring up Marc Edwards in Wyoming, where Bruce Gilbert was impeached by the judge as unqualified. Took the testimony anyway. It's not fair. See, normal people who question things, who are skeptical, can see that that's not fair. So just because Judge Boone did it and he's, a federal judge, just because he said it doesn't mean it's right. Just because a federal panel affirmed it doesn't mean it's right. Wow. There's so much. And here, like I've said so many times, the Shaw case, this is textbook for what happened to Jim. By going outside the evidence, the prosecutor violated a fundamental rule known to every lawyer. Argument is limited to the facts and evidence. You have to have facts. And they didn't have it. Any contention that Evan Moses was a qualified witness is wrong. And if there's any merit to that whatsoever, the fact that there was a recording of him admitting to not being qualified. I love how they want it both ways, these scumbags. Evan Moses is God's messenger right here on earth. He is a prophet of God. He said Jim is a citizen. He said Jim is required to do this. And it has to be true. He is God's messenger. Yeah, but he did say he wasn't qualified, had no evidence. Oh, no. That's no, we can't believe that. The audacity of these people. Well, because they got cheerleaders like Wes. The audacity to say it's fair to deny somebody cross-examination of the only witness against them. And they ignore the fact again. They don't say anywhere in this decision that it was fair to hold Evan Moses' opinions as irrefutable. They don't say that. They're too vague. All they said that they did not clearly err. What, are they trying to say that because he did err? Where is the prima facie burden? A prima facie burden. Okay, I'll have that up here. A prima facie burden is not met by a conclusory statement. I didn't make that up. That's Iqbal. Ashcroft versus Iqbal. That's the standard. So, saying that Jim failed to rebut that, you're just lying. You're just lying. He did. He showed it was a conclusory statement. The rules require facts. He had no facts. He admitted he had no facts. He admitted he wasn't qualified to even make the statement. So again, Wes, pull your lips off of Boone's ass and the appellate panel's asses and apply some critical thought. But people like that won't do that because all they want to do is lie. They want to lie and lie and lie. Because just because we don't have things thrown out just because the cop doesn't show up. And to say that that's the only reason why any of our tickets were thrown out is just wrong. We had a felony drug possession and cultivation charge thrown out in Idaho. And the cop was on the stand for the prelim. It was thrown out at the prelim. So the idea that we've never gotten it thrown out is just wrong. It's just wrong. I'll have to do a short video where I just lay everything out and show how dishonest these people are. I don't think I doing it this way. I was a little bit. I went off focus for a while. Well, let's talk about. Let me see. Let me see if we can get the caller. Okay, we have another call. We have Neo in Riverside. Neo, welcome back to the show. You have an update for us?
Well, yeah, actually, I got a court trial coming up on the 21st, this Friday. And unfortunately, due to my own personal procrastination thing, I never filed any of the motion to strike or any other attachments. So I just got the trial coming up and just kind of wondering if any of the things I've watched in the past, the whole, the legal definition of the state of California, if any of that kind of stuff, cross-examining, and it's kind of funny, I'm just jumped out on the line right now. I heard you talking about them lying about, giving evidence without, they can't even qualify for the evidence and they still take it. But anyways, I just didn't do any of my due diligence, and I'm just wondering if there's anything I could do at the trial to either still challenge jurisdiction or cross-examine the officer with certain questions to expose that he's not qualified.
Well, yeah, and they'll actually be the ones to say he's not qualified. His own attorneys, and by that I mean the prosecutor and the prosecutor with the robe on, the judge. His own attorneys will say he's not qualified to keep him from saying it himself. Mm-hmm. Because if he says it like Evan Moses did before a confrontation, they just cancel the confrontation. So one of the best things that we can do when we go into these situations is whenever you're talking to somebody who's attacking you from the government, okay, the state government or feds, you got to assume that every single thing that they're saying is a lie or a half-truth. These people absolutely cannot be honest other than to say, well, when they start talking about violence, they will carry out their threats of violence. They're being honest about that. They will hurt you. So start with that, and you should be role-playing. And the assumption is that everything is a lie, and your job is to ask questions, not make arguments, Ask questions to bring out their contradictions that what they're saying is absolutely false. So as far as you still can challenge jurisdiction, because these pricks will still always say jurisdiction's a trial issue. Once you get to trial, then they may change that tune. Oh, you should have raised that in pretrial. And you're like, if I could just punch you in the face and walk away, I would. Because that's what you deserve right now. You lying sack of crap, you. Or like, you meathead, you. You still can and you should. I would still file the paperwork and say we're not ready to proceed. We got a pending motion to dismiss. And if the prosecution has the evidence, then we don't have to even have a trial. I'll plead guilty right now. Now, if that doesn't go well and you make your objections and they force the witness on the stand, you need to object to the witness being on the stand because the prosecution can't show personal knowledge of the matter she's testifying to. So just like Evan Moses, the cop is going to be there to testify that you violated the law. He's already said that. It's prior testimony. It's under oath. It's certified. That's prior testimony. Okay? So they're going to tell you to go F yourself in a legal way, and they're going to just overrule your objection. And that's fine. Our job is to show the contradictions which discredits them. So when you get the chance to cross-examine, and I'm going to go through this again, the two questions you need to start your cross-examination with are these. You're going to get him to confirm his position, which he's already testified to. Did you determine on your own that just because you saw me physically in California that the laws applied and that there was jurisdiction to stop me and give me a ticket? Now, I get that that's a compound question, but they're going to allow it. Mm-hmm. If you have to break it down because the prosecutor is really being the prick, just break it down. So if he says objection, compound question, break it down. Did you determine on your own that just because I'm in California, physically in California, don't say state, you're physically in California, that your laws apply to me? Yes. And you determined on your own that because the laws applied to me, you had jurisdiction to stop me? Yes. And because you had jurisdiction to stop me and you did, you charged me with a violation of the law. Yeah. So you go humor them and break it down if you have to. No one has ever reported that they had. Yeah, no one has ever reported they had to do that because it's a question that, even though it's a compound question, it helps the prosecution. They're just restating their position anyway. So they usually don't object. I've never heard it. Now, the problem comes in for them when you follow that up and you ask them, what evidence, if any, do you have to prove that just because I'm physically in California, your constitution and laws apply to me? And that's when the prosecutors jump out of their chair screaming, objection, calls for a legal conclusion. Now, I did a whole video about this not too long ago. I think it was part of the show. And because we have an appeal here in Arizona where they said that the objection was proper because it called for a legal conclusion. Now, there's a lot of problems there because you didn't ask for a legal conclusion. You already did that with the first question, and there was no objection. You're asking for the evidence that the legal conclusion was based, so the objection is not even on point. Mm-hmm. And two, and this is something you want to bring out, you want to say, is the prosecution saying that the witness isn't qualified to make legal determinations? And if so, does that mean he wasn't qualified to write the ticket? Does that seem to you?
How would they answer? Well, I follow that. It's a little bit different than the other things that I've seen on the videos. How's that shown up in how the judge or the prosecutor handle it in other places up to this point? What have you heard them what other lie or bullshit do they normally come up with?
They just lie. They will lie and say he is. The typical one is just to ignore the question and just like a straw man type of thing. He is only here to testify to the facts, sir. Move on. And you say, well, that's what my question was about. I asked him for the facts. It goes directly to his prior testimony and goes directly to what happened at the stop. I just asked for the facts. Do you want me to ask the question again? Do we have a recording? You want to listen to it? You knucklehead? See, this is the evidence of the bias, though, Neo. When people say that we have no evidence of bias, if you're asking for the facts the conclusion was based on, and they say he can't answer that because he's only there to testify to the facts, come on. These are not stupid people. They're just trying to put something over on you, and they're trying to use legalese to confuse you. Sir, he's only here to testify to the facts. Did you hear the question? Do we have to have it read back to you? And yes, I get a little perturbed, and my Sicilian gets up here a little bit because these are real people. You're a real person who's going in, and you're going to hear these things. And it's frustrating because this is our lives. This might not affect you irreparably, but this could cost you thousands in insurance. This could really hurt you. And the flippantness and the callousness that these people exhibit. And they'll say, no, your objection's not, you move on. You cannot ask them those questions. No, objection. Are you telling me that on cross-examination? And you should be asking this. Are you telling me on cross-examination prior statements are not relevant?
Okay.
Always put in the form of a question. Say, are you telling me competency and credibility are not relevant issues for cross-examination? Always use the word relevant when it comes to it, because the only discretion that judge has is to limit cross-examination to relevant issues. And prior testimony is always relevant. Mm-hmm. So the typical response there is to not only not allow you to do that, impeach their own witness, but to deny you an opportunity for a defense, because you can call the cop as your witness. You have, that's part of it. Okay, so you could put on your own defense, which is depending on what kind of situation. But the point is, they usually deny you that. So what you can do at this point, you can say, wait a minute. Let me see if I understand you correctly. Are you telling me in plain English that this police officer is not qualified to accuse me of violating the law? Because that's exactly what a legal conclusion is. And don't let them trick you. Say, well, wait a minute. Isn't saying they violated the law a legal conclusion or a legal opinion? Is he qualified to do that or not? Because if he wasn't qualified, and you say, well, objection, I move to strike his testimony, including what started this. I move to strike his conclusions, legal conclusions from the ticket. And yes, you can strike charging instruments. Anyone who disagrees is lying to you. You can strike a charging instrument. They do it in the tax court all the time. So that, in a nutshell, know the tactic that we're going in. The reason why we're able to ask these questions and formulate questions that shut them down to where they're just babbling, stupid things, is by keeping the burden of proof on the prosecutor where it belongs and not making affirmative statements yourself. If you want to say it's unfair, that's fine. You don't say it as an affirmative statement. You do it in the form of a question. It's just like with like when it comes to arguing without evidence. You always put it in the form of a question. Would it be fair if I argue without evidence? Do I get to argue against the prosecution without evidence? No. Well, isn't that unfair to allow the prosecution to do it? Or are they going to sit there and cry like Maria did? We wouldn't be able to prosecute anybody if we had approved jurisdiction. So, before we're out of time here, do you have any other questions about what's going to happen on Friday?
Well, I'm pretty sure they're going to throw a whole bunch of stuff. Is there a couple videos that you would point to that was recently done that kind of covers exactly what you said, so I can kind of review that and hear it over again in different? Which one's is it on your website or what?
The last few videos, that's what I've talked about. I've talked about appealable errors, and I've talked about the justification that Patricia Starr, that's always funny, that she gave in. She's a Phoenix judge who I talked at length about the denial of cross-examination and her lame justification for that, and. Just right. It goes back to everything they're saying is a lie. Everything they're saying is a distraction. They're always strawmanning. They're never answering you directly, usually. And if they do answer you directly, it's usually so vague that you have to ask a follow-up question to understand really what exactly it is they're talking about. And so you're gearing your who, what, why, who, what, where, when, why, and how questions to bringing out those contradictions. And we do that by getting more specific with our questions, asking them leading questions so that they're getting more and more specific. And I say, all right, so this is important. I've been covering this almost every show now. Do you know what a leading question is as opposed to a non-leading question?
Do I? Are you asking me that?
Yeah.
I know vaguely, but not specifically.
Okay. Which is another way of saying you don't. And that's fine. Most people don't.
Yeah.
A leading question narrows the focus of the response. It's yes or no. And you have the information in the question. So a leading question would be, when you stop, you determined on your own that just because I was physically in Arizona, your constitutional laws applied and you had jurisdiction to stop me. That's a leading question because the information is in there. He either admits it or denies it. A non-leading question would be, why did you determine you had jurisdiction?
Okay, I see. That makes it clear.
So he has to supply the information. So Also keep in mind too, on direct. So when the prosecutor is doing his direct examination, if he asks a question that's a leading question, you have to object. Objection leading. If he asks a question that's so open-ended it requires the police officer to give an extended narrative, you object. You say objection narrative. If he says that you violated the law, objection lack of foundation or assumes facts not in evidence. He's assuming the laws apply to you. Okay, so those are some of the major objections. So every single question you are asking on cross-examination, every question you are putting to the prosecutor and the judge should be a leading question. Okay, you're going to be 100 times more effective by asking leading questions because you have to keep the focus on the prosecution's burden of proof. See, you've got two people butting heads here. Your whole position is they have no evidence, and I'm going to keep focusing on that lack of evidence, their burden of proof, until we get an admission. Their job is to keep your focus off of their burden of proof. And that's what you're going to see on Friday. Every single time you do something and say something that's effective and keeps the burden on the prosecution, they will respond by trying to distract and get the focus off of that. Well, where's the evidence to prosecute? Where is the prosecution's evidence, facts proving the proposition, the information proving the claim is true? Where is that? Well, don't you have a driver's license? Objection. Are you saying that the prosecution's evidence is on the driver's license? Or that the driver's? Are you saying that the prosecution's? Are you saying that the driver's license is evidence proving the Constitution applies? You keep the focus on the issue at hand. And the single most important issue for you on Friday is the lack of evidence the prosecution has to prove his foundational claim. You should be...
Which is the jurisdiction.
Which is jurisdiction it's jurisdiction. It's also part of subject matter jurisdiction because they're accusing you of violating their laws. It's mala prohibita. It's not a legal wrong, or it's not the violation of a legal right without the code. It's not a real crime like murder or rape, which exist without the code. That's wrong without the code. This is wrong just because they said so. So they have to prove that. So just have your BS meter going, and because it's going to be tapping many times. They'll say jurisdiction
every single time. Sure.
Well,
Go ahead.
This goes up. You have to call back. I won't be live on Saturday, but you'll have to call next Wednesday and report to what happened. Oh, is it this Friday or a week from Friday?
It's this Friday.
Oh, this Friday's not the. I thought you said it was the 20.
Yeah, 21st.
21st. Oh, 20. I misheard. I'm sorry. You need to call next Wednesday. I mean, let me know what happens on Friday, but definitely call in and report because I want you to be able to give us personal knowledge, report from personal knowledge that they told you some of these lies, like jurisdiction's a pure issue of law. It requires no evidence. We just have to know where you physically were. You probably hear something like that. Mm-hmm. They'll fight you tooth and nail and do everything they can to get that scumbag cop on the stand. And then they'll fight you on cross-examination if you do it right. If you ask those 2 questions and you ask only leading questions, they will impeach their own witness against you.
Okay, so the 2 questions were, once again, did you determine on your own that because I was physically in California that you had jurisdiction? I didn't get all the whole
Well,
words,
did you, and this is, hopefully get this posted, well, definitely be posted by tomorrow. Did you determine on your own that just because you saw me physically in California that meant your laws applied and that you had jurisdiction to stop me?
Okay.
And remember, there are 2 issues of jurisdiction here. It's not just an issue of jurisdiction with the court. Did the cop have jurisdiction to stop you? And that's a part of, and that's why it goes through, why it's so important to bring that out on cross-examination. Did he have now, to them, it's based on, yeah, of course he did. Well, do you have any proof? The audacity, the cruelty of these people, that you're sitting in a court and they're going to make a claim and say, he doesn't need proof. Well, how much more proof do you need, Neo, that you're not in a legitimate court when they say something like that?
I don't need that. I'm pretty clear about that part.
Yeah, that's pretty obvious. So get to role playing and remember your basic principles. Hold them to their burden of proof by asking questions. Always ask clarifying questions, and always go from their vague statements and admissions and go and get more and more specific. Because when you start doing that, their lack of evidence will become apparent.
So the first one was basically determined on your own that I'm physically in California, that your laws apply to me and you had jurisdiction to stop me.
Yes.
And the second one was because the laws you determined.
Do you have, what evidence did you rely on to prove that just because I'm physically in California, your Constitution applies to me?
Okay.
See, you got to keep in mind that you have to show relevance to your questions. It's very easy to do, but you got to do that because you know in advance that the prosecutor is going to object to the question for evidence. You know that. We all know that. So the first question, it sets the relevance. Okay? And we're taking a statement we know is true. We know that's what he's done. They'll tell you that. We've had them testify to that 1,000 times. We've had even a critic say, if you're physically in California, the laws apply, end of discussion. We know that's their position. We know the cop was thinking that that was the process when he stopped you and wrote the ticket. We know that. So we get him to restate his prior statements. And we ask him for the evidence. So we've set the relevance. We have proven the relevance. It doesn't matter if people like Wes Serra want to deny that. They're just being dishonest. They can't explain to you why the officer's statement at the stop and on the ticket are somehow irrelevant to the trial. They'll never give you anything specific about why that's not relevant. They'll just say, you're a douche, you're an idiot, you're a wacko, you're a scumbag anarchist. It just is. And we've heard prosecutors actually say that. It just is. Or it just does. Stop asking me for... Anyway, so we're running out of time here. So those are the 2 questions, but you need to still do the role-playing and prepare for this.
Gotcha. And that's on the Skype call, you said? Or
yeah. Skype? Yeah, they'll probably be doing one right after the show.
Okay.
All right?
And the videos are on your website?
The videos are all on the website. They're also on my YouTube channel. It's No State Project, and of course they're all embedded in on my website. I've been a little behind as far as embedding and doing articles for the last couple of videos, but you can definitely just go to my YouTube channel, No State Project, and you can get them all there.
Okay. Thanks a lot.
You're welcome. Hey, good luck, and let us know what happens.
I shall.
All right, Neo in Riverside going into the Lion's Den on Friday. And, they are crooks. And I'm not going to make a conclusory statement without proof. I'm not like Wes Serra. I'm not a bureaucrat. I'm not some scumbag politician. If I make a claim, You can bet I got some proof. They are criminals because, as we say on the show all the time, they're just men and women forcing us to pay them. And that is a statement of irrefutable fact. That is not my opinion. That is what happens. It's even in their sacred code that Wes loves from the hand of God himself. And God said, you will pay taxes. Not a shred of evidence any of it applies. Why? Because there is no government. They are literally, I'm using it right, men and women forcing us to pay them. Now, you can justify that however you want. You cannot change those facts. Wise man, conforms his beliefs to the evidence. I think I'm butchering that a little bit, but you get the idea. The belief should conform to the evidence. Men and women forcing us to pay them. And that's exactly why these prosecutors and former whatever, these people who are apologists for this criminal organization called government, it's why they can't produce a single shred of evidence that reciprocal obligations of allegiance and protection were created. Why? Because the facts are dead set in opposition. You do not create an obligation of allegiance and protection by forcing people to pay you. And it's not a matter of society can make their own rules, because society is being forced to pay. That kind of negates all that society is in control. Well, society can make their own rules. It's a democracy. Yeah, but the facts are against that. That's a nice philosophical or civic type statement, but there's no evidence. Everyone is forced to pay. No one voluntarily pays. So there's no duty of allegiance, no duty of protection. There is no body politic. There is no state, and therefore there is no government. If you want to show that I'm wrong, don't just make an ad hominem that I'm an idiot. You're going to have to produce the evidence. And maybe when you see that the evidence I've presented, that they're just men and women forcing us to pay them, when you see that it's absolutely irrefutable, it's insurmountable, and it is so damning as evidence, it couldn't possibly be reciprocal obligations. You see, Wes, and apologists like that, the state doesn't exist just because you say so. The government doesn't exist just because you say so. And it doesn't not exist because I say so. It's because the evidence does. If the evidence bothers you, hey, I understand that. It bothers the hell out of me. But you have to have your belief consistent with what the data tells you. So if you want to think, hey, and I understand you spend your career as a prosecutor. You are a very well-off man. I get it. You're very comfortable. People in your position are. You have a monopoly, a violent monopoly. You get to charge a lot more money than people would normally pay you. I get it. You've built your whole life on this lie, and you don't want to admit that it is a lie. But we're going to continue to expose you as a liar. Because every time you lie about me, I'm going to show the proof that you are lying. We're going to show how dishonest you are by, again, we're going to do what we can. Let's start a pledge. You'll have to get on the forum to do that. We're going to start a pledge page. We'll see how much money we can get pledged for Wes's favorite charity. What do you got to lose, big guy? What do you got to lose? Come on the show. Show the evidence proving that there's reciprocal obligations of allegiance and protection. Bring a justification to show that just because the motion was granted, you're still right to say that every single court has denied my motion. Go ahead. Let's see it. We do a live broadcast most time twice a week. 4 hours of live broadcasting. And again, you don't trust me. You've not been able to show where I've lied one time or I've cheated a customer who all pay me voluntarily, unlike you. You don't trust me? Set up another live broadcast. Set up another day. It doesn't have to be on a radio show, but you just set it up. I'm more than happy. Anybody says that what I presented on the show is wrong, that my analysis is incorrect, that you have evidence where I say you don't, where you have a rational basis where I say you don't, you're more than welcome to call the show. I'll set you up as a guest ahead of time, or I'll do another live broadcast. But we're at a time here on episode 26 of the No State Project. The issues that I did talk about, Gabe, are appealable issues. Denial of cross-examination, huge denial of a motion to dismiss based on lack of evidence proving jurisdiction, appealable error. A lack of evidence proving jurisdiction or just a lack of jurisdiction, period, is always a good appealable error. Always. Ignoring evidence, lying for the prosecution. Those are great appealable issues. Does the judge have discretion to lie his prosecuting ass off? No. That's a no-brainer. It should be. But again, if you disagree, give us a call during a live broadcast. We won't be live this Wednesday, this Saturday, but we will be live again this time next Wednesday. And so I do appreciate everyone supporting the show. EO, I do appreciate that, and Non-Entity, of course, for his continued support of the show. I do appreciate that. We wish Neo luck in Riverside this Friday. Hopefully we get a good report from him next Wednesday. Again, my name is Marc Stevens. This has been the No State Project live for July 19th, 2017, and episode 26 of the commercial-free broadcast. And so what we'll say is, till next time, salud.